My name is Szonja Csörgő, and I work for ESA, which is the European Seed Association, and I'm responsible for legal affairs, including access to genetic resources. So that also is one of the reasons why I was invited to this workshop today, which is very, very relevant, since it talks about access and benefit sharing, in particular in the context of the Nagoya Protocol, which is a new, well, fairly new instrument in the field of our sector. Well, what is the Nagoya Protocol? The Nagoya Protocol is actually a protocol to the Convention on Biological Diversity, which is an international agreement that was adopted in 1992. And already the Convention on Biological Diversity sets out some basic rules about access and benefit sharing with regard to genetic resources. However, the concrete framework how such access and benefit sharing should take place was not put in the Convention on Biological Diversity. That's why a few years later, in 2010, the contracting parties to the CBD decided to put in place the Nagoya Protocol, which is again an international agreement that basically details how access to genetic resources should take place and how the benefit sharing should also work. Nevertheless, since this is an international agreement, it has to be transposed into national law, so the countries who ratify the Nagoya Protocol have to adopt national laws where they put national access and benefit sharing rules in place. So this is where we come basically to our sector, because it's going to be the question whether the genetic resources a company wants to access is falling under such a national legislation on access and benefit sharing. And it will really be a patchwork all over the world, because it's up to the countries to put in place such legislation or not. So a country, when it ratifies the Nagoya Protocol, can decide whether it wants to have an access law on the national level or not. And today we understand that this is going to be the case for Spain, that there is going to be a national law on access, but this is not the case for all the European countries, because there are many countries who decided not to have access laws. Nevertheless, there is the European regulation, which also implements parts of the Nagoya Protocol, not on access and benefit sharing, but on compliance measures. So there will be, or there is already, a European framework to check whether users have complied with national access and benefit sharing laws when they accessed genetic resources they have used in their research and development, and whether when they put products on the market in the EU which result from the use of such genetic resources, then they will have to fulfill the compliance measures of the European regulation. And this legal framework, which was adopted in 2014, is a very new one. Still, a lot of questions are not so clear how it should be implemented really in practice, and a lot of countries, member states of the EU, are still not so advanced in their national implementation. So in some countries there are already checks which are starting. In some countries the national laws are not yet in place, which would nominate or designate the national authorities to do the controls. So it's a little bit work in progress. But it's definitely a new legal framework with new obligations for the sector, which are very key, because it affects the day-to-day work. And you really have to know whether you comply with the national ABS legislation in the country where you access the genetic resource. Otherwise, you are not in a legally secure environment, and you are not going to start working with that material, which is very different from a situation we might have had a couple of years ago. That's why it's very important for us as an association to make sure that our members know how to follow the new rules of this EU regulation, and this is why we are in the framework of, or in the process of, developing recommendations for our members, which hopefully will help their day-to-day compliance.